Good morning. My name is Diane Miller. I'm an attorney in the United States. I am a director for National Health Freedom Coalition and National Health Freedom Action. Thank you so much for inviting me, Tomas Pfeiffer and Dr. Bashwadi, to be here at the World Health Congress 2023 Prague. I would like to share with you some concepts about legal issues for practitioners and products that I hope you can apply in your own country, in your own locality, and think about as you go forward in your practices. And thank you for all your great work in the world. I have a PowerPoint I'm going to share with you today, and it's good to be here. Like I said, I am with the National Health Freedom Coalition in the United States, and we do a lot of education about legal issues regarding healthcare. First of all, we always ask the question, where do people turn when they need healing? And obviously, most people seek trusted sources, whether it's their family or practitioners in their community. So now there are experts, pharmaceutical and surgical medicine, that are market dominant. So most people go to the doctor or they go to conventional medicine. And a lot of the other options are not very visible in the marketplace. But that's changing. Here is a graphic from the Institute for Complementary and Integrative Medicine that really shows all of what you all are doing in your practices: CAM, energy therapies, mind-body therapies, reflexology, chiropractor, and these are not often in the dominant pharmaceutical model of care. There is bias and suppression in cultures and in marketplaces, and this is an issue that has become more prominent as the pharmaceutical and drug industry has developed over the years. I think many people think healing is an art. Some people are better at it than others. Some people think healing is a science, and there's only one way to get better, and that has to have scientific proof. And I know that both of those are going to be addressed by many of you today. But I am here to address healing as law, because laws reflect the culture that you're in. So the constitution of all of your countries is the law of the land in your locality, and they have authority to make and enforce laws, and sometimes those laws affect healthcare. The U.S. Constitution has an amendment, First Amendment, and it says, "The Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble, and to petition the government for a redress of grievances." This is a very powerful part of the law of the United States, because a lot of healing is religion, a lot of healing is speech, a lot of healing is people gathering, and it is very helpful for us to have this kind of environment. But why are the TCIM practitioners and products shut down, or ignored, or vilified? I am here to help you look to the law, not just public policy or what your local community is thinking. I like to look and see what is actually in the law. These are some of the laws that may impact what you are doing in your healing practices. There's the constitutional law for your patients for protecting their personal freedoms. There's product law. There's emergency health powers law. There's occupational licensing boards. There's civil law. There's criminal law. There's all kinds of law that really are dictating what your environment looks like about privilege. Today, I just want to make a few comments on 3 areas that I think are extremely important. Product law is very important, practitioners and what they can do, and the personal freedoms law for the patients. So let's start out with personal freedom, just because we have been through a global change in how governments look at personal freedoms given the pandemic issues that have arisen. In Minnesota, we wrote a law 20 years ago when they were trying to change the Emergency Powers Acts of Minnesota to give more power to the governor over people. And we said, even in a time out of an emergency, we drafted this law, and it says, notwithstanding laws in response to a national security emergency or peacetime, individuals have a fundamental right to refuse medical treatment, testing, physical or mental exam, vaccinations, participation in experimental procedures, etc. And so we value this law, and it wouldn't be on the books if the people of the country didn't come forward and pass that law. In the United States, I'm heading up a project with a group of people from about 5 states, and we call it the Right to Refuse Project, because many people think that they don't have the right to protect their own bodies, their own autonomies, and they have a hard time speaking up to their practitioners because they think they need to be doing what they're told. And so we have the Right to Refuse movement, and we're passing laws that help people realize they have the right to make their own choices in healthcare. In terms of product law, for example, in the United States, and I'm sure in every state there's something where you define what a drug is. A drug in the United States is an article intended for the use in diagnosis, cure, mitigation, treatment, and also articles intended to affect the structure or function. But in 1994, the agencies were shutting down people using natural substances because they were intended to use for healing. And so a very big movement happened, and we put the change in the words, and it said articles other than food, because before that, even food could be shut down as a not evidence-based drug. So now that we have other than food, they decided to define a category of food called dietary supplements. Homeopathic remedies, and I'll go back to the other slide, is in the first article. Articles recognized in the official homeopathic pharmacopoeia are drugs, and they are still not considered food. So homeopathic remedy products are regulated in the United States by the federal government. They are regulated as drugs still. And sadly, and we're working on that to hopefully change that, but the status of homeopathic remedies in the United States is they are unapproved drugs, and there are no currently homeopathic approved drugs that are FDA approved. So this is a real problem, and I have a whole presentation on drug law for homeopathic products. Dietary supplements, however, are food. They're regulated as food, vitamins, minerals, amino acids, herbs. Many of these dietary supplements in the United States are regulated as food and available to consumers. And the real legal issue that is very powerful in the United States, not true in many countries, is that they have a presumption of safety like food. So they are generally regarded as safe. The burden of proof is on the government to show harm before restricting. So they're considered food, and they're not taken off the market unless they don't abide by the good manufacturing practices, or unless they are considered dangerous by the FDA, and the FDA has to prove that. Occupation law, we have many practitioners of many different kinds, and it's always important to see what the laws in your locality are. For example, in my state of Minnesota, and generally practitioners are regulated by their local governments, The practice of medicine is defined as anyone who offers or undertakes to prevent or diagnose, correct, or treat by any means a defect of a person. So you can see that that's an extremely broad definition of what it means to practice medicine. And if you're not licensed, it is a gross misdemeanor criminally. However, these licensed people are uniquely privileged, and they have their own restrictions, but they have a lot of privilege to practice, and they have boards that regulate what they do. The boards say whether a practitioner is practicing within a definition of their occupation, whether they have required education and exams, their authority to enforce the occupational law. There's a lot of power that are given to executive boards to regulate practitioners. But in these exemptions, for people who are in that very broad definition of the practice of medicine, I worked on a case one time when a farmer was shut down for practicing medicine because he was curing people with the colostrum from his cows, his dairy cows. And so I looked at that law to see if there were any exemptions to that very broad definition for needing a license to practice. And I saw that there was an exemption in Minnesota for anybody who is healing and curing, it says prevent or cure disease exclusively by mental or spiritual means or by prayer. That's an exemption for the criminal law in Minnesota. But that wasn't large enough exemption for me because we were working with a farmer. And I thought, what about the homeopaths? What about the traditional naturopaths? What about the herbalist? So we passed a law for unlicensed complementary and alternative healthcare. And that has to do with acupressure, anthroposophy, aromatherapy, Ayurveda, cranial sacral, and we exempted all of these practices out of the criminal charges. A big issue today is the loss of license of doctors once they get their license. What are the grounds for disciplinary actions? Well, in Minnesota, we have a law that says you could be shut down for unprofessional conduct if you were not conforming to the minimal standards of acceptable and preventing medical practice, in which proceeding actually injury to a patient need not be established. Well, that could mean a lot of things. The standard of care, if you're outside or on the fringe of standard of care in the conventional community, you could lose your license. And right now, there are doctors losing their license for maybe recommending a parent hold off on getting a vaccine, or maybe they're doing chelation, or maybe they're doing some cancer protocol that is not a conventional one. So this is a very important issue for medical doctors and many licensed people of other kinds as well. So in our work, we have developed a model bill for the expanded practice for licensed people. So if they want to be licensed and they want to do things that are risky and need regulation, then the expanded practices will let them go outside of that standard of care unless it is more dangerous than what they otherwise would have done. And so it's basically a safe harbor for the licensed practices. And many states have gone forward to pass small little expanded practice models over the last 20 years, but they're not lengthy, they're not written so that there's no loopholes in them. And so recently we are going to be promoting our legal way to address the expanded practice law. And Utah has done a good job just this year passing an expanded practice act. They call it the Best Practice Act, I believe, allowing their licensed practitioners to do things that their patients agree to that are not posing a risk of harm. So it is very important that we make sure that not only the licensed professionals are able to practice, but the unlicensed people are able to practice, and all the healing options are available to consumers. We think that the burden of proof needs to be on the government to show harm by clear and convincing evidence before restricting products or practitioners to make a real full environment. And we design legislation for the future in our organization. So I encourage you to all be agents of change, and this is our organization. And I see my time is up. So thank you so much for your time today, and thank you for all your healing in the world. And I look forward to seeing you in person someday. Thank you.